Making Excuses and Debt Law and Litigation. Brought to you by yourlegallegup.com, your advantage if you're being sued by debt collectors. Hi, we live in a society where people often value sincerity more than integrity. Consequently, most of the time, if you make a mistake, people will forgive it and you if you can only make a good enough apology. Debt law, and especially the litigation part of it, are not quite like that. It's an adjustment you need to make if you're being sued. First, let's talk about debts, the substantive debt law. If the debt collector can show that you borrowed money or used credit and did not pay it back, plus the other parts of its case, they will get a judgment against you. Simple as that. Does it matter why you couldn't pay? Health issues, sick children, lost job, whatever? No, none of that matters. These real-life problems do not excuse the debt. As the law sees it, the creditor, and the debt collector is a creditor for this purpose, lent you the money, and it's up to you to solve your own problems and pay the money back. Although there are sometimes excusing events provided by contract or law, but we're not talking about those here. They don't apply to many debt law cases. Bankruptcy is a minor exception to the rule sometimes. It does no good to complain that Citibank has trillions and you're broke. Except for bankruptcy, the law regards that as purely your issue. Therefore, you should never admit the debt, claim some sort of hardship, and offer payments when you're being sued, at least not if you hope to avoid a judgment. Your chance is only in making the debt collector prove its case by legitimate evidence. Luckily, that's a very good chance. And that brings us to litigation and the court. The legal system is designed to balance the need for efficiency against perfect justice as defined by the law. What that means is that the judges are supposed to balance looking at the substantive merits of the case against technical violations and favor substance most of the time. And actually, they do a pretty good job of that in general, with caveats. More specifically, if you're late in answering the petition or getting discovery back or anything like that, the court could cut you some slack. Although this might require a lot of effort on your part and some luck, and especially, for example, in the case of answering the petition, if you're late on that, you'd need to do a special motion, which might or might not be granted. However, if anything gives the court the feeling that you're taking advantage of this leniency in any way, or that you aren't taking things seriously enough, they can and will slam you. It can be a judgment call. I encourage you to remember that there is an institutional bias against pro se debt defendants. The court may be inclined to think that you aren't taking things seriously as you should. Be that as it may, the less you ask of any judge, the lower your chance of being disappointed are. Take all deadlines ultra seriously, and remember, if it looks like you'll be late, it's much better and easier to ask for extra time before than it is to be late and ask the judge for permission to do it afterwards. If you ask for extra time before, you're scheduling or planning, and if you ask for permission afterwards, you are making excuses. Although, if that's all you can do, you should do it. Courts do care about your sincerity, in other words, but you are a tiny part of their day most of the time. There comes a point, quickly for some judges, less so for others, where you're just in the way. Other people have rights too. If you reach that point, there's probably not going to be a good enough excuse to keep you from getting run over. Be there on time. Do the things you need to do on time. Find out all the tricky little rules that could mess you up. Require yourself to be as good at this as you possibly can be. Accept no excuses from yourself. Then you do have a great chance to win. Protect what's yours and don't let the debt collectors rip you off. yourlegallegup.com